What impressed y'all the most about what you saw in the movie?
It seemed really raw.
What?
It seemed raw and real.
Yeah. That Pacino was really genuine, very genuine. A little naive,
Mm-hmm.
idealistic.
I thought it was crazy, like in some parts, like that you could go to jail and be in there even though you didn't do anything. And
You get the wrong, there's many people who have had the wrong name when they got stopped at a traffic stop, and they ran the name and a warrant came up for that name, but it was the wrong person. You know, those kind of things do happen. Well, I guess what we could do is go ahead and pick up where we left off last week on our lecture. We had talked about courts in general, and I wanted to go ahead and start picking it up at talking about the judge. Before this class, what do y'all think that a judge did?
send people to jail.
Just send people to jail.
Pretty much.
You know, and it really makes kind of sense. The only time we ever really hear about what a judge does is when he's sitting in a court making rulings. You know, you can do this and you can't do that. But there's a lot more to being a judge than that. Of course, supposed to be neutral in overseeing the court case. He's supposed to be very knowledgeable about the law. He has a lot of discretion in his courtroom about what can and cannot be done. I don't think I ever really thought of him being a negotiator. What do y'all think about that?
I wouldn't have thought that either about him being negotiated, because he's not, you never see like in movies or any sort of media him arguing any sort of case or it seems like all he ever does is listen and he decides like what would he negotiate.
Exactly. Well, whenever you have them retire to judges' chambers, things change. And, you know, the judge might say, you know, this case is garbage. I don't want to waste my time on this. I don't want to waste the taxpayers' money. I want you to come up with a settlement within the next 72 hours. You know, they'll do things like that. And, you know, the lawyers do not want to get on the bad side of a judge. And, you know, they'll try their best to go ahead and do what he says there and come up with some kind of a deal, you know. He'll oversee plea bargains. And, you know, they'll come to him in the chambers and they'll say, well, you know, we've got this and this and this that we've worked out, you know, will you sign off on it? And, you know, he'll, okay, I'll do that, and then they'll meet in court and go ahead and proceed. He has a lot of discretion in the sentencing. Unless there's a mandatory sentence, he's got complete discretion on what he can and cannot do. And then he also is in control of bail conditions. You know, anything from no bail whatsoever to in the millions. But remember, it's supposed to be a reasonable bail according to the Constitution. Now, I could see it being, you know, $10 million for, let's say, $10 million bail for George W. Bush. Okay, he's done something and they arrest him, on a felony, and, the judge knows he's gotta set a bail. And he's gotta keep him in the jail, so, okay, $10 million. Well, depending on who the person is, what the crime is, the means that the person has, the flight risk they are, all those go into consideration for bail. I will go into the administrative duties in a minute, but I had never thought about him being the administrator of the courthouse. He has to have knowledge of the law, has to be fair, has to have good communication skills, good good decision-making skills. Question is, why become a judge? Well, it brings a lot of high status. They will have lawyers that will step down from a very, very lucrative practice to become a judge for the status. Mostly the judges are white men, strong political connections. Only 7% of state trial lawyers are African American, only 4% are Hispanic, and only 25% are women. The way a person becomes a judge, there's basically 3 ways. First, if a governor appoints them, okay? Presidential appointment. We're going through a really, really contested Supreme Court justice nomination right now. And so that's an example, for a federal judge, a gubernatorial appointment for a justice would be one way. Another way is if the legislature selects a judge. Then we've got a merit system, and this is where judges are nominated by a commission. They are appointed by the governor for a period of time, and then they go up for vote. Now, the way this works is they will have a selection committee, and they will review all the possible candidates, and then they will weed those out and maybe make a recommendation of three or 4 of those. Then the governor will choose one of those, and they will serve like 4 years, and then the people decide if they want them to serve another term. And so that's a pretty neat way of doing it. Then there's nonpartisan election. That's what we do in Arkansas. We have our judges run, but they don't run as a Democrat or a Republican. Even though they may have affiliations with a party, they are not on the ticket as such. And then there is partisan elections, where they openly disclose what party that they are associated with. What would be the downside of a partisan election?
They could seem biased.
What?
They might seem biased.
They might seem biased. Okay. That's a great point. Would they lean more toward, party selections? If we have partisan elections, usually then the 2 parties will get involved, and you get to wondering, kind of like what you're saying, do the judge owe them something? And so then you start wondering if the bias comes in, and how much of a puppet string that might be being pulled. The prosecutorial system. Remember, this is where you have 2 sides arguing in front of a judge. You have the prosecuting attorney, and the other side is the defense attorney. The prosecuting attorney is the legal representative for the state. He has the sole responsibility for bringing criminal charges, and the United States attorneys are the prosecutors for the federal cases. Now, for the state cases, it's attorney generals. Like if they wanted to sue the tobacco industry, you might have several of the state attorney generals join together in a suit against tobacco companies, and so they represent the state. State attorney general, they're the chief legal officer of the state. Normally, these are going to be elected. They have the power to bring prosecutions. Then you have your United States attorneys. There's one U.S. attorney and a staff of assistant U.S. attorneys. We have, I'm trying to think where they're located, but I do think they had at least one U.S. attorney working in the child pornography area with the state guys working together, because it goes across state lines and even international lines. They prosecute cases in each of the 94 U.S. district courts. They are responsible for the prosecution of crimes that violate the federal laws. All right. One thing, especially about attorney generals, they will use that position as a springboard to a higher position. If you'll notice, so many of our governors, they were attorney generals before they became our governor. And so this is very quite, this happens quite often. The prosecutor, he's going to be involved throughout most of the process. He's linked to all the other actors in the judicial or the court system, okay? He works with the police, he'll be working with the witnesses, he'll be working with the judge, he'll be talking and communicating with the defense, so he is interacting with everybody. And it is the prosecutor who makes the recommendations. He decides if they're going to prosecute or if they're going to drop the case. He decides what charges. He decides how serious of a crime they're going to be charged with, or if they're going to go with what they know that they can get. It's terrible the way that some of our system has digressed. Just like that clip we just saw, it's getting to be a numbers game. And the prosecutors basically will not take something to court unless they're just 90% sure they're going to win it. And so it shouldn't be that way. It should be fair for everybody. And that's what's sad. And sometimes what they'll do is they'll go ahead and they know they've got a weak case, so they'll plea bargain it. And sometimes they'll knock the charges down. So let me think. There was a child abuse case where the child was raped and really kind of brutalized, but they did not have the evidence to really prove which one of the parents did it. And so they charged one of the parents with child endangerment. Prosecutor, he will work as trial counsel for the police. And so the police can call them up and say, hey, what do we need to do this? How do we need to do that? Or can we get a warrant from you on such and such? So they work with the police to try and build that case and to make sure that the I's are dotted and T's are crossed along the way for the due process. They also are house counsel for the police. We'll get into that in another slide in just a minute. They represent the court and they are elected. there's a thing called prosecutorial discretion, and I just basically talked about that. They decide which cases to prosecute, they'll negotiate plea bargains, and they'll determine the number of counts in which to charge. There's a different type of philosophy on prosecutors and cops on this. Some will use the shotgun approach, or the scattergun approach, and they'll nail them with every possible thing that they can think of and charge them with everything they can think of and hope something sticks. And others say, no, what we're going to do is we're going to go for the sure thing. We're going to go for the bullet. And so it depends on the prosecutor, and that's the discretion. Procedures and activities of the prosecutor. Well, discovery, that's when they are trying to get all the evidence, all the information about the case, and then they'll decide if they're going to charge and what counts charged from. Here we have the key relationships that the prosecutor interacts with. Like I said, the police, the victim, witnesses. I left out the judge. They work a lot with the judge, also in the community. The decision-making process of the prosecutor, accusatory process. Some prosecutors' offices make extensive use of screening and how best to use the limited sources. So, decision-making process, basically a lot of it depends, do they have enough staff, do they have enough money, and do they have a good enough case? The defense attorney, he represents the accused. He will advise the defendant during questioning. He will represent the defendant at arraignment and hearing, and he would also serve as an advocate for the defendant during trial and appeal. Now, why would somebody want to become a defense attorney? I mean, they are not as, you'd think that, they'd be wealthy as some of these attorneys on TV and such, but a lot of times if they don't get the money up front, they don't get the money. Because, like look at O.J. Simpson, okay? He ran up millions of dollars in his court costs, in his lawyer fees, and then he didn't pay them. He said, I don't have it. Said, my estate's gone now. And so here these guys put in an incredible amount of time. And so I think part of it is he signed over some of the rights of the story and such to them. But still, if he didn't have that, that's a perfect example of how an attorney, a defense attorney, they may put in all that time and get very little for it. It's not unusual for a defense attorney to ask for their money up front. That way, if they win, great. If they lose, they know they've got their money. They represent the defendant at arraignment and hearing, and they are an advocate for the defendant during the trial and appeal. Some of the things that they will tell you is that one of the downsides is people think that they're either inexperienced or incompetent. Well, they can't. What kind of a person would defend this person, or they couldn't get anybody else, so they got this guy. There are three groups of defense attorneys. You've got your well-known, your high fees. You've got somebody that's chosen and affordable to those that can pay it. And then you've got your regular ones that, they'll take cases for small fees, and those are the ones that feel like they kinda get the bad rep. Downsides. There's a lot of emotional stress with being a defense attorney. What would be some of the things that would stress an attorney out on something like that?
Ethical crisis.
Ethical questions? What else?
Put away an innocent person.
What if I lose and this guy's really innocent? What else?
And vice versa, hitting
Yeah,
somebody who's
let
guilty.
somebody guilty go.
Yeah, and setting somebody free that's guilty. Anything else?
Making connections, or trying to not make yourself personally connected, like with the child you were talking about.
Absolutely.
Yeah, you're not supposed to.
Yeah, try not to get emotionally
You're not supposed to
attached.
give information about your person.
What about one of the most often asked questions to defense attorneys? How can you get somebody off that you know is guilty? How would you like to hear that every day? Again, many of them receive poor pay. If you don't get it up front, you may not get it at all. And it can have an emotional toll if they have a lot of losses. And like I said, a lot of prosecutors will not take a case to trial unless they're 90% chance they're gonna win it. And so, the defense attorney may have a lot of losses that they have to deal with. Wonder also how that affects their relationship with their family. Wonder if it has an effect on their outlook on life. You know, as much as I really, really appreciate Mike, for 30 years he has seen the bad and the worst of the worst. And now his outlook is, you know, he doesn't expect good from people. And that's sad, but it's true, you know. He has a kind of a dark outlook on some of that. Then we have people that cannot afford their counsel. They're called indigents. But they have a Sixth Amendment right to counsel. Well, there's 3 types of ways that these people are taken care of. I don't know if you remember the first film that I showed you or that you saw called Nuts. And when Claudia punched out her first lawyer and he said, I want off this case, I want off this case. And they said, well, you know, she's got to have a lawyer. And okay, I'll appoint one. And then this guy was trying to escape out the door. And, you know, he, come on back. I got you. I got you. And they can assign just about anybody they want. Now, who's going to say no to a judge? This is a private attorney that's assigned and they are paid for, but this is the one that the judge decides who's going to represent them. The contract counsel. Now, a lot of times what they'll have is a law firm that works out a deal with the county or region, and they'll say, okay, we'll handle this many cases, court-appointed cases, and we'll take them on for this amount of money. And so that's a contract system. And then there's the public defender. These are full-time salaried employees of the county, of the state. And honestly, some of them are really, really good because they specialize in nothing but criminal law. And some of them can be really slick, okay? Let's see here. Some of the downsides, what's one of the downsides of being a defense attorney? Public defense attorney.
You have to take cases you don't want to.
Absolutely. Have to take cases you don't want to. What else? Overload. They are absolutely swamped and overloaded, understaffed. Now, what does that mean? Not enough people, but it also means they may not get the full attention in that case that needs to be done. They also do not have the investigators that the prosecution has. Okay? I thought I had another slide here. I guess that was it. Are there any questions? Okay. Well, we're going to move on to the next chapter on Wednesday, and we're pretty well on track. I'm very pleased. So we're hanging in there, and we're getting it done. Any questions over anything we talked about today? I'm going to go ahead and close out Unit 1 completely. I'll wait until Friday. I'll make an announcement on the blackboard, but it's going to be closed out and closed out for good. Okay? So if you want to go back and take an exam once more, try and get the best you can, that's fine. I think everybody in here had an excellent grade, so you may not want to, but if you do, feel free. It'll be open to, I'll probably close it sometime on Friday, okay? All right, well, let's get your little cleanup sheets.
About the term paper, I lost my paper. I already did the assignment, but I lost, I don't know if you want how many words.
I didn't have an actual word count. I said I wanted you to make sure that you covered it exactly like that form that I gave you.
I know, and I lost it.
I've got one for you.
Okay. I did it how I figured you would want it.
I think I already turned mine in, so.
Do what?
I turned in my term thing, so.
If you'll do it Wednesday.
I think I already turned mine in, I think.
I hadn't received it.
I'll have to double check.
You said turn it in Wednesday?
He wants to know if he can turn it in early.
Oh, okay. When is it due?
The next to the last week of
Thanksgiving?
semester. Do what?
Oh, I thought you said before Thanksgiving. I thought it was
Oh, I'm sorry. I got you mixed up with another class. I think I said the class right
The class before Thanksgiving?
Yeah, last class before Thanksgiving.
I'm not gonna finish.
Anybody else got anything?
What exactly is Unit 1? Like, which